Hello, estate planning mom here, Krista Hermance. So I'm here for my weekly questions and answers on estate planning. So whatever questions you have, I'm here to answer them for you. So if you are just joining me, please make sure to post your estate planning questions in the comment section, and I will try to get to those. I do have some questions that came in through email that I'm going to get to as well. And if you are comfortable putting your questions in the comment section, you can always email me info@hermanslaw.com for any questions that you have on estate planning. I understand that this is a public forum, and so you may not want to post your question, and I totally understand that. We also have a lot of information. If you're looking for free printables, trying to get organized, get things set up, go to our website, hermanslaw.com. In the resources tab, there's a freebie section that has a lot of different resources available. So beneficiary designations, figuring out exactly how many different accounts you have, all of the beneficiaries that are associated with those. If you want to start organizing what accounts you have, what retirement accounts you have, really trying to get that stuff in order. A lot of free printables on there for you. If you have any questions, you can feel free to text or call our office 805-518-9633. Okay, so first question that I'm going to get to, and again, if you're just joining me and you have any questions on estate planning, what is a will, what is a trust, a power of attorney, advanced healthcare directive, all of these kind of terms that you might hear, please make sure to post those questions in the comments. Okay, so first question is, what is the difference between a power of attorney and a will? So I find that people do get confused with some of these terms because sometimes they mean different things in different places. And so in California, which is where I practice and where our offices are located, we have a power of attorney document that we use. We also have a will, which is different than a living will. And so sometimes people do get confused by the different terms of what each legal document does. So a power of attorney is a document that allows you to identify an agent to be able to make financial decisions on your behalf if you are unable to do so. When you identify a power of attorney, this is somebody where an agent essentially would be able to step into your shoes to be able to make those financial decisions for you. So going to the post office, filing tax returns, going to the bank, selling a house, anything that from a financial perspective that the powers are listed in their power of attorney document, it would give that agent the ability to do. In California, we also have the ability to do what we call a springing power of attorney. So it doesn't spring into effect immediately upon signing. It's only upon some type of event, like if you were to become incapacitated. And so I really like that option for our clients that are healthy and don't need a power of attorney in place at that exact moment. It gives the option that it only becomes effective and in place if something actually happens, some type of incapacitating event. On the other side of that, though, if you have a family member that is, I see it a lot where we have family where a parent is getting older and they don't want they want to give that power away, then to give them the power of attorney to be the agent and have the ability to go to the bank and do things for them, then they will sign it that it's immediately that power of attorney is valid and working. Okay, so on the other side of that is the will, and these are different. So power of attorney is where you identify an agent to be able to make financial decisions on your behalf. A will is a legal document that when somebody passes away, it's filed with the probate court. And what the will does is it allows you to identify who you want as your executor, the person who would administer your estate. It allows you to put other specific instructions in there, like how do you want your stuff distributed? How do you want your assets distributed? Do you want it to be shared equally between your kids? Do you want a certain amount to go to somebody else? Do you go to a charity? Whatever you want, you put that in your will. If you have minor children, a will is also a place for you to nominate guardians for your minor children. There's also, if you want to be buried or cremated, that can also go into your will. So there's all these kind of things that go into your will, but that is a document that is filed with the probate court upon somebody passing away. So that is obviously the biggest difference is what a power of attorney does is financial agents, and then the will, where you identify how, when you pass away, how you want your stuff distributed and things taken care of. Okay. The other side of that, I'll introduce one more document to you, is the Advanced Healthcare Directive. And that one is very similar to the power of attorney document, but this is where you identify an agent to be able to make healthcare decisions on your behalf if you are unable to do so. Oftentimes I see people getting this confused with a living will, because in California we call it an Advanced Healthcare Directive, but some people know it as a living will, and they get that confused with a will. So I understand lots of documents, lots of different names, and it can be confusing. And so that is hopefully why I'm here, to help kind of clear up any of those questions, as well as if you want to move forward and get planning done. If you don't have a will in place, a trust, power of attorney, Advanced Healthcare Directive, if you don't have any of these documents and you want to get your legal planning done, estate planning that we do, you can give us a call. You can go on our website, schedule an appointment, and we are here to assist you with that. Okay, so if you're just joining us, please make sure to post any questions that you have in the comment section, and I will try to get to those. As always, you can email us, info@hermanslaw.com, if you have any questions at all, and then always feel free to visit our website, hermanslaw.com, for any information. There's a ton of information on the website about services that we provide, explaining what different things are. Those are all there for you to be able to look at when it's convenient for you. And you can also call or text our office, 805-518-9633. Okay, let's get to our next question. How do I avoid having to go through probate court for my parents? So this comes up generally. I would see this when parents have passed away and their child is then having to administer their estate. So if that's what this question is referring to, there may not be a way to avoid probate court if the parents have already passed away. So let's assume for this question that the parents have passed away and you are trying to avoid probate court for administering their estate. So first thing is looking at what assets they have. So generally with probate court, the reason for having to go through probate court is if they passed away with any assets in their name, then it would have to go through probate court for that probate proceeding to essentially be able to say, well, these are who the beneficiaries or heirs are, and this is how it's going to be distributed, either according to their will, because if you have a will, it still has to go through probate court. That doesn't, it's a myth I hear people say a lot, I have a will, it's going to avoid probate. That's not true. All a will does is guarantee probate court. So the court's either going to look at a will, or if there is no will, intestate law to say how your stuff's distributed. So, so if there's any assets in their name personally, so if they owned a home and the home was in their name personally, if they had any bank accounts, if they had any type of brokerage accounts, investment accounts, and didn't have any beneficiary designations, these are assets that they would have that would be in their name personally and would have to go through the probate process. If something has already happened to the parent, there's no planning that can be done. It's the after portion, when somebody passes away, that would then need to be administered. And so there isn't a way to avoid probate for those specific things because no pre-planning was done. And that's why it's so important to get that planning done in place before something happens to somebody, because then it goes the way that you would want it to go. A lot of people don't really understand that, you know, what the probate process is, and that's one of the reasons why I come on here, is to educate and just really make it known, because if that's not what you would want, you can put plans in place to make sure that that's avoided. So let's take it on the other side. Or I'm sorry, one more thing there. So if they have assets that are have a beneficiary designation, maybe like a retirement account or an investment account with a beneficiary designation, life insurance. So those are things that avoid probate because they have a beneficiary designation. And so unless they are to minor children, which I get into a lot because we do try and do a lot of plans where we're protecting kids, and kids wouldn't be able to actually receive that money until they were 18. And so we do specific planning to make sure that kids wouldn't be receiving any type of money like that. But if it was an adult and they had, and they were getting money from a life insurance policy or retirement accounts, that avoids probate, right? It passes outside of probate because it's beneficiary designation. So that's one way to avoid probate court. The other thing is depending on if they owned a home, how they held title to that home. So One way that I see people being able to avoid probate court, one is by putting a deed in their name jointly, like as joint tenants. And so what that means is that if one of them were to pass away, the other one would then just receive all of the house, and it would avoid probate in that sense. I do not recommend that being the only planning tool. So one of the things that we do when we work with clients is we create a trust. And what that trust allows them to do is to be able to create this trust that says, if something were to happen to me, this is how I would want my stuff distributed. And then you put all your stuff in the name of your trust. It's a revocable living trust here in California, and including your house, right? And so then if something happens to you, you don't have any assets in your name, it avoids that probate process. And that's how you avoid probate, but you have to get the planning done first. So hopefully that gives you an idea of how to avoid probate. The biggest thing is doing planning early, while you're healthy. I see it so often where people have a family member that gets ill and they get to the point that they don't legally have the capacity to make decisions on their behalf. And so it's important that the planning is done before that event takes place. And it allows them the ability to make decisions for themselves, to say what they would want, and to put it all legally in writing. Because without these documents, that's generally where court involvement is needed. And so by doing this pre-planning, while it does cost money, it's generally not as much money without having plans in place, because probate is expensive. Dealing with the court, dealing with attorneys from that aspect, it is very expensive. And that's something I'm going to talk about next week, is the cost associated with it, because I do have something that's actually launching on my website this week that I'm very excited about, and I will share details, so more to come on that. Okay. If you are just joining me, if you have any questions, please post your questions in the comment section, and I will try and get to that. If you have a question and you don't really feel comfortable sharing it here, please email us info@hermanslaw.com. You are always welcome to visit our website, hermanslaw.com, for any questions you have. There is a ton of information on there. You can also call or text our office, 805-518-9633. Okay, let's get to our next question here. How do I pick someone to make medical decisions for me? So a really great question. This is one of the things that when it comes to kind of working with our clients and counseling them on picking people that we talk through. So it's important to pick someone that you trust, that you feel is going to make the decisions that you would want, that they're going to follow those. And so one of the documents that we use, and I mentioned it a little earlier, is the Advanced Healthcare Directive. So this is a document where you identify an agent to be able to make healthcare decisions on your behalf if you are unable to do so. And it also has other certain end-of-life decisions. These include, do you want to be buried? Do you want to be cremated? Do you want to do any type of organ donation for transplant purposes? Do you want to be taken off life support with no extreme measures if you are in a persistent vegetative state? So all super serious questions. I get it. It's hard to talk about. But without having these documents, there's nothing legally documented that says what your wishes are. And so one of the great things about having this Advanced Healthcare Directive done is it allows you to identify who you want in these roles as your agent, and then also what these decisions are. And so when you're looking at picking an agent, I generally recommend having one primary and then two backups. So you're going to have a total of three. And if you are married, usually your spouse would be your primary agent, and then you would have backups after that. So that if something happened to your spouse, then you would have an agent that's already listed there. You want to look at the qualifications of the people that you're choosing. And so if you're having a hard time, picking, and you have like this list in your head of who you want, what experience do they have in healthcare? Are they a doctor? Are they a nurse? Do they have any medical background? Is there anything that can help assist them in trying to make these kind of decisions? So that's one thing to take into consideration. I will say from an agent perspective, you can choose anybody as your agent as long as they're over 18. If you have an adult child, you can choose them as your agent, spouse, family members, friends, neighbors. It's not limited to just your family. So if you have people that you're really close with, they're not related, they can absolutely be your agent. You should talk to them though, right? So if you are completing these documents, you're completing an advanced healthcare directive or any of your planning documents, and you're listing them as an agent, it's a good idea that you talk to them and just, say, hey, I'm working on these documents. I'd like to list you down as a potential agent. Are you okay with it? And then talk to them about what you want. I see it a lot where people don't want to talk to them and tell them they're doing this or ask them, but it's always good to have that conversation so that they know. And most of the times they will say yes, but you won't know until you talk to them. And so that's why it's really important to make sure that you are talking to them. Okay, I think we have time for one more question. So if you are joining us, please make sure to post your questions in the comments. You can always email us info@hermanslaw.com. Visit our website, hermanslaw.com. Lots of resources there. Or as always, call or text our office, 805-518-9633. Okay, last question I have for today is, how do I protect my son's inheritance from my ex-husband? So there's a few different ways to do this. I will say my number one is by setting up a trust. So this is our trust plan that we have. So the estate planning packages that we do, our trust plan is our most common. It's got all of the different documents in there to make sure that your wishes are documented, your family is protected the way that you want it. So by having a trust, it allows you to say, if something happened to me, this is how I would want my assets distributed. And it allows you the ability to say, like for your son, how you would want any money that would be going to your son to be held in trust for him throughout his lifetime. And what this allows you to do is it allows you to pick a successor trustee, the person who would be able to manage the trust on your behalf if something happened to you. And that person can be anybody you choose. And so what that's going to do is it's going to allow them to manage the assets rather than it going to your son. And I'm assuming he's a minor at this point, just an assumption. So whereas if there was nothing in place, then your ex-husband would likely be the guardian of his estate and be in charge of the money. And so by putting it in the trust, it allows you to identify somebody to be in charge of the money and manage it, and where it wouldn't be managed by the ex-husband. That's generally what I will talk to people about and saying how to put plans in place to protect them. Other things to take in mind is, do you have retirement accounts? Do you have life insurance? Same kind of premise. If your son is going to receive that money as a life insurance beneficiary and he's under 18, if he gets that money, it's not actually going to him personally. It's going to go into a court-appointed account where generally the other parent would be in charge of it. And so then your ex-husband could potentially have access to it to manage it on behalf of your son. Whereas if you had a trust set up, you could have the trust as the beneficiary, and then that money would go into trust to be distributed according to your wishes by the person that you choose to manage the money. And so that's generally my recommendation for when there are exes and you're just trying to make sure that the inheritance for your child is protected. Okay, that is all I have for questions for this week. I do have one quick announcement I just want to share, as it's something that's coming within the next few weeks, and I'm really excited about it. So we have a brand new workshop that I'm going to be doing. It is on getting your estate plan in order. So I'm literally going to be walking through with you in this webinar to help decide who do you want as agents, who do you want as the important people, and I'm going to have a worksheet for you to be able to fill out and literally start working through this, because that's one of the biggest things I hear from people is they can't decide on who they want. And so that is my goal with this workshop, is to help you get it in writing and start thinking about it. It is going to be on Thursday, August 27th at 7 p.m. It is an online free workshop. It's going to be about an hour, because we're going to go through a lot of the information as to what is included in a plan, and then again talking through and trying to work through who you want as agents. Okay, so that again is August 27th, so stay tuned for more details on that to come. So thanks for joining me, and if you have any questions, I will be back next week, Wednesday at 6 o'clock. And if you don't want to wait till then, of course, always feel free to email us info@hermanslaw.com or visit our website, hermanslaw.com. Thank you so much. Have a great day.